Now we're going to talk about the pretrial and trial process and procedures. So this is the point upon arrest. We have the pretrial process. It's the process leading up to or what happens before a defendant has a trial. And there's a number of steps along the way. One of the, I kind of want to clear up misconception, hopefully. Take, for example, the prison break that occurred here a few years ago in Dannemora, right? David Sweat was one of the inmates who escaped, and he was caught. He was brought to court for his arraignment, and he was charged. He was charged with escape. That was the top count. There was a couple others. And it was obvious, right? Obvious that he was guilty. He escaped. How could he possibly plead not guilty? But at that arraignment, he enters a not guilty plea. And of course, that gets on the news, and how can it possibly be? It is an arraignment is a formality. Can a person plead guilty at arraignment? Sure, they can. It's very rare because it's really a step in the process, and some other things have to happen before a court can take a felony plea. So I just want to have that out there, keep that in mind. And before, Chapter 8 is focusing a little bit at the beginning on bail, but I can't just jump right into bail without giving you a little bit of background about where we are when bail happens. It just doesn't poof, oh, look, there's bail. It happens at the point of arraignment. And we're going to expand on arraignment a little bit after we talk about bail. But I need to bring it to the forefront right now so you have a clear idea of how bail works. So, arraignment, a person who is charged is brought before the court. We'll call them the defendant at this point because they have charges. The court reads the charges, advises the person of the max penalty they are facing, advises them of their rights, and there's a number of rights, and we'll get to those. And one of those rights is they have a right to an attorney. And they ask at that point, do you want one? And if the person says yes, the process actually stops. And either there's an assignment of counsel or the person retains their own counsel, as we talked about defense counsel. And then arraignment picks up at another time. And it could be later that day. It could be within the hour. It could be the next day. But it picks up because the person is entitled to have an attorney at arraignment. And New York State actually requires one to be right available. So there is always an attorney, defense attorney in court at the time of arraignment to assist the defendant in the process. So, and this happens because it's at that point at arraignment, the judge is going to be talking about bail, and depending on what happens, a person can lose their liberty even before they're found guilty of the charge. So that's why I wanted to set the stage here with giving you an idea of where this bail comes into play. And it's at arraignment when the person has counsel. Also at that time, the judge will enter a plea, guilty or not guilty. And some people, like I said, this isn't the negotiation process. So 9.9 times out of 10, the person's going to enter, the attorney's going to enter a not guilty plea at that point. And then bail. Then there's this discussion regarding bail, and it's the court that sets the bail. What is bail? It's a monetary amount that is paid by or on behalf of the defendant for the condition to be released while the case is pending. What's its purpose? Its sole purpose is to ensure the defendant's appearance at every required court appearance. That's what it is, not to punish the defendant. So what happens if the defendant doesn't show up? They forfeit that money. There's a warrant that gets placed out there for arrest with the law enforcement agency that charged the crime. The defendant can be charged once they're picked up with bail jumping. And ultimately, they can be detained without bail until their cases are now resolved. So that is a serious consequence of not showing up to court. What happens if the defendant can't make their bail? then the defendant is going to be detained until the case is resolved or till he or she can make bail. So let's talk specifically about what it is. The right. Does the defendant have a constitutional right to bail or to have bail set? The answer is no. The Eighth Amendment merely prohibits excessive bail. But what is excessive is kind of a very gray area because it's within the discretion of the court to set bail. And there's no limit on the amount a court can impose for bail. If someone's charged with murder, the court can set $1 million+ bail. For a charge of petty larceny, stealing groceries from the store, would $1 million bail be excessive? Absolutely. It'd be excessive. It's more in the range of $250 to $1,000, depending on, and we'll talk about circumstances coming up. They may even be released without any bail. But the point is, bail cannot be used as a punishment. It's only to secure the defendant's appearance. And the court just can't slap an amount on of bail willy-nilly, and they can't certainly change it. Once they've set it, there's been a discussion on it, a hearing on it, on the amount, the judge just can't change it. Come back the next week, I think it should be higher. There has to be a change in the circumstances that results in a discussion with regards to a change in bail, whether to the benefit of the defendant or, not to the benefit of the defendant. So how it is set depends on the court, whether we're in state court or federal court. A state court, there's a hearing at the arraignment stage, and the defendant is free to ask for bail review at any time during the course of the case if there's new information that wasn't available or known at the time of this hearing. The court looks at the charges involved, any prior criminal history or criminal record of the individual, the residence, where do they live? Do they have a home? How long they've been there? Do they have ties to this community? Meaning, is their family here? Do they have kids here? Do they work here? What's their employment status? Are there drug and alcohol issues involved? What kind of statements were made from victims or possible witnesses? What's the victim's status? Are they let's say it's a domestic violence case. Is the victim at the home? And if we release or set this bail, are we going to let this person go back to the house where this incident may have happened? So there's a number of things that the court considers before setting bail or considers bail. So let's talk about how a defendant can be released, the specific components of bail. Bail is just a general term, but there's a number of components to it. And I like to go in. I should have set my list up this way. The list is set up as the book. I set them up as the way they're discussed in court, with the best option to the worst option available. So if you're a defendant, the option you certainly want is ROR, or released on own recognizance. And this is a release on a promise that you'll appear to court. You don't have to post any money. You don't have to post any bond. We'll get to those in a moment. You are free to go on your word that you'll return to court. Usually this is for really low-level offenses, first-time offenders, in the community, traffic infraction, disorderly conduct, maybe a petty theft or a simple assault. Released on own recognizance. That is one way a defendant can be released. Conditional bail, and this is released ROR. I'm going to use the short ROR with conditions. The court might require conditions. Like if it's a DWI, you have to go get an evaluation for alcohol abuse and not get arrested during the period of your case is happening. Don't commit a crime, don't get another arrest. I'm going to release you. This is a conditional bail. Otherwise, I'm going to set bail on you. Pretrial release or pretrial services, not on my list, but it is a type of release for the defendant. And this is where someone is released without bail. Judge doesn't send them out of bail. And they're not released ROR. This is a direct order from the court. Pretrial services or pretrial release. But the person must be supervised. This is an extension or an arm of the probation department. They're not on probation. They just have to check in, make daily phone calls. Yep, I'm here. Everything's good. I'm following the conditions or the curfew or the drug testing that the court set for me to do. So these are like the judge gives conditions, but there's someone you need to check in with to make sure you're doing what you're doing. They might get drug tested when they go visit this person. Make sure they're doing the requirements that the court set out for them. So the court will require, before this happens, the court will require an interview to occur with the pretrial services to verify the information that the defendant provides. The employment status, the community ties, whether they have an address and phone number where they can be contacted and found. All of that has to be verified and checked out before the court will place somebody on a pretrial services. And then the person who's doing the monitoring reports back to the court of how the person is doing. So that's pretrial services or pretrial release, as they call it in New York State. And then there's full cash bail. This is extremely common. The first three are the ROR, the pretrial release, and full cash bail are the three common ones. Well, three common ones up to the beginning of the year, and I'll explain the New York State reform in a moment. Full cash bail. So the judge sets bail at $1,000 on the pledge that the property, they pay $1,000 in cash. They appear in court. The promise is to appear in court, and they get their money back at the end of the case, or it's returned to whoever posted it at the end of the case, less any sort of fee. The New York State charges a 3%, what they call poundage fee, that they take out of the bail money, like for holding the money. There's deposit bail, not so common here. Defendant deposits a percentage of the bail, not the full amount of bail. And when the defendant appears in court, that could be returned. If not, they're responsible to pay the entire amount. So if the court sets a bail at let's say at $10,000, bail's $10,000, they only have to put a percentage, 10%, so they pay $1,000. And he'll get the defendant will get that $1,000 back when the case is done. But if they fail to appear, his bail is now $10,000. So once they are arrested for failing to appear, they're required to pay the full amount to be released. Surety bail or surety bond is another name for it. Defendant pays a percentage of a bond. This is common too in New York. The court will normally set a cash bond scenario, and it's usually a surety bail. And the defendant pays a percentage of a bond, 10%, to a bail bondsman, who then posts the full bail. Sounds like a nice job for a bondsman, right? And that money, that 10%, that's what it is in New York, 10%, that money is not returned to the defendant. And the defendant must post collateral to cover the full amount. So, and when that collateral is always real estate, because real estate is worth the most and it doesn't depreciate and it can't be damaged so easily like a vehicle can, or disappear so easily like a vehicle can. So if the bail is set at $10,000 and a family member goes to a bondsman, the bondsman will pay 10%, they'll pay the bondsman 10%, which is $1,000, who will then take that $1,000 and the 9 and pay the bail. And he retains the ability to seek full payment of that money if the defendant doesn't show up by a lien on a piece of real estate. And if, the defendant, doesn't show, obviously that 10 grand gets forfeited, but the lien on the property should secure the bondsman. However, some bondsmen, they hire a bounty hunter, right? This is what the bounty hunters do. They go out and try and find those folks who've skipped out on the money. And I won't go into this, but that's where those guys come in. Those people come in. An unsecured bond is release without requirement to pay anything. Unsecured bond is the release without requirement to pay anything. A defendant promises in a written agreement that they will pay a certain amount of money if they fail to break conditions or don't show up. Okay, this is not backed by a bondsman. This is the unsecured bond to the court. This is a direct agreement with the court that if they don't show up, they're going to pay a bond that they're going to have to pay for. That one's uncommon. Federal court. And all of those things are in state and federal court available, but federal court has a little caveat to their bail, so I want to bring it up here. In federal court, the statute or the law says there is a presumption of release with conditions or supervision. So when a defendant walks into a federal courtroom, they're already presumed to be released with, we'll call it pretrial services, with conditions or supervision. That's where the court starts. It's the government's job to show that this individual is dangerous to the community or a flight risk in order to overcome that status and have the court detain them or set a bail in addition to. There are certain crimes in the federal law system where detention is presumed, unless the defendant can show there's a reason for their release, and those are the serious crimes. I just want to put that little caveat in there relative to federal. Do you see any issues with bail? Is there a problem with bail? Do you see any unfairness to it? How about those who are well off can pay bail and those who are indigent cannot? I've seen people with $250 bail on a petty larceny because they, stole some food from Price Chopper or stole some items from the Dollar General, sit in jail on a $250 bail because they couldn't make it. Couldn't post the bail. They're not a danger to society. And this, in turn, results in taxpayers having to pay for that person to sit in jail. What if that person did have a job? Now they've lost their job, right? The other problem that stems from this is there's innocent people who plead guilty just to get out of jail, get out of paying bail. Because a case can sit for, if we're talking about a misdemeanor, anywhere up to six months. And that's if it's on the fast track of the speedy trial, which we won't get into because there's some things that have to happen in between. But there are some misdemeanor cases that go on 2-3 years. So innocent people plead guilty just to get out, right? They're accused of stealing. Bail set, they can't make it. They sit there for a month to their next court date. Now they've lost their job, can't pay their bills. And then the DA will come in with a plea offer that will say, well, plead to this nice little violation here and do some community service and you can go home, right? Or pay this small fine and you can go home. And then you don't have a criminal record. So maybe I'll take it just to get out of jail, right? There are times, and I'm going to use this example again, petty larceny. There are times when a petty larceny, a small theft crime, something less than $1,000, won't even result in a jail sentence, even if after trial won't result in a jail sentence. Could be some sort of supervision or community service, but that person has now sat in jail on bail, and that could be longer. So there's a number of issues surrounding bail. Those things are the primary factors surrounding bail reform. And as you may be aware of, New York State went through and passed radical bail reform laws. And it's certainly hotly contested still. You can read about it all on social media of the different types of things that are going on, that it went from one extreme to the next extreme. Basically what it did was it took out, in a general sense, it took out discretion from the judges who are not particularly happy, that may use bail as a form of punishment, because the reality is you're innocent until proven guilty, the constitutional right, and bail is not supposed to be used as a punishment factor. And what is, we'll see what happens. We'll see what the research says. This is a fairly new reform in New York. But some of the laws that have passed regarding bail works in big urban areas. I believe it would work and works down near New York City. But when you're in a rural, small community, and we have a lot of folks that come up to the North Country from New York and Schenectady and Utica to traffic drugs here. And if they are caught here, and with the new bail laws, they're allowed, drugs, selling drugs is not a violent crime, so it's not a mandatory bail now under the rules. So they're required to be released on their own recognizance, and then they don't show up. And they don't come back. And then there's a warrant, and then we got to try and find, then, law enforcement has to try and find them. And that seems to be one of the biggest complaints. There's a few other I won't go into, but there's only a handful of crimes now, violent crimes, violent felonies, that allow for bail to be set at arraignment now in New York State. And there's a lot of crimes, especially sex crimes against children, that allow a defendant to go free. And there's big complaints regarding that. You think that's good? What was the purpose of bail again? Not to punish someone? Innocent until proven guilty? I think New York State reform bail is one of the issues that you could choose as one of your topics. This is a hot button topic. So here's a question that I am going to pose. How many of you think that more than half the people released on bail, i.e. if they've paid money, never show up for their scheduled court dates? What do you think that number is? It's only about 1%. That's a small percentage. Why do you think that is? Because most of the time it's somebody else's money who's done the posting, and the defendant wants to make sure that person gets their money back. Do you think that number would go up if people were just released on their own recognizance with a promise to come back to court? I don't think there's an answer to that question, but I'll let you think about it. But these are the things you should be aware of relative to bail. So the next topic, we're going to talk about charging the defendant.